A very good morning to all of you. So we'll just continue with our series of lecture. We have been discussing the previous year questions with regard to polity for the last 15 years, and we have been discussing it theme wise. And in the last lecture, we are discussing the theme that was related to the legislature, and we'll continue doing that because the legislature part is not yet done. If time permits, today we'll complete the legislature and then we'll move on to judiciary. And once we are done with judiciary, we will be left with three more topics, that is local bodies, constitutional bodies, and the miscellaneous topics. So we'll try to wrap up this series of lecture in another couple of classes, and that's the plan as of now. And I hope that this series will be really helpful to the students who are preparing for the prelims 2023. So we'll directly get into the question, and I think in the last class we have done with question number 100. So we'll be moving on to the next question. So let me just go to the appropriate question. So we were in question number 1. So let's go to the question. Okay, come to question number 101. The first question for today. So look into this particular question. When the annual budget is not passed by the Lok Sabha, if there is no annual budget that is passed by the Lok Sabha, so what is likely to happen if the annual budget is not passed? So the budget is very important thing. When we talk of budget, the immediate thing that should come to your notice is Article 112 of the Constitution. So Article 112 of the Constitution talks about the annual financial statement. So it is a responsibility of the President to lay down the annual financial statement. So usually on behalf of the President, because the President is the head of the Union Executive, it is laid down by the Finance Minister. The Finance Minister lays down this particular budget, and the Finance Minister lays down in both the houses of the Parliament. Initially in the Lok Sabha, then it is also laid down in the Rajya Sabha. So this is the understanding that you should have, and then the budget goes through a series of process. And after the completion of the appropriation bill and also the finance bill, the budget is deemed to be passed. So with this information, come to the particular question. When the annual union budget is not passed in the Lok Sabha, which of the following is the right answer here? The budget is modified and presented again. No, that does not happen. The budget has to be passed. It has to be passed. It can be modified. The grants can be modified during the discussion, but you cannot do it once again. Come to statement number 2. The budget is referred to the Rajya Sabha for suggestions. Of course, it will be discussed in the Rajya Sabha also, but most of the functions like demand for grants, the passing of appropriation bill with regard to the passing of the finance bill, the Lok Sabha has got more powers. So it is not referred to the Rajya Sabha for suggestion. The Union Finance Minister is asked to resign. No, that does not happen, because it is not that just the Union Finance Minister will have to resign, but rather the entire government has to resign. If the budget is not passed, then it is automatically deemed to be a no confidence motion, or you can consider that the government is not having the majority. Okay, so the right answer in this particular case is option D. So the Prime Minister submits a resignation of the Council of Ministers. The entire government is not having the majority, and that is probably the reason they are not able to get the budget passed. So this is the understanding that you should have. The right answer is option D in this particular case. Okay, so we'll move to the next question. So come to this particular question. Which one of the following is responsible for the preparation and presentation of the union budget to the Parliament? So who has to actually prepare the budget? The budget preparation should be the responsibility of the Department of Economic Affairs. Under the Transaction of Business Rules 1961, which the President can do under Article 77 of the Constitution, which I already discussed, it is the responsibility of the Department of Economic Affairs, and within the Department of Economic Affairs, there is something which is called as budget division. So in case if they ask about the division, you should also remember budget division. The budget division which works under the Department of Economic Affairs. Department of the Economic Affairs. In fact, the Department of Economic Affairs will start working and consolidating the budget somewhere in the month of say September, October, which is when they start, and they complete their process by end of January or by end of December or by mid of January, before the next financial year comes. And then it is presented to the Finance Minister, and then the Finance Minister will in turn lay the budget in the houses of the Parliament. So this is how it happened. So what is the answer in this particular case? The answer is the Department of Economic Affairs. Please understand, very, very important. Which ministry does that? It is the Finance Ministry, and within the Finance Ministry, it is the Department of Economic Affairs, and within the Department of Economic Affairs, it is the Budget Division. We'll move to the next question. So come to the next question. Consider the following statements. The Constitution of India provides. So this question is specifically related to the legislature of the states. So let us try to understand as to what the legislature of the states say. Statement 1. The Legislative Assembly of each state shall consist of not more than 450 members chosen by direct election from territorial constituencies. While this particular statement is partially true because it talks about territorial constituencies and every person shall be elected by direct election. While that is true, what is not true is the limit that is given in this particular question. It talks about 450 members. The Constitution does not say 450 members. The Constitution say it shall not be less than 60 members and it shall not be more than 500. So the range has to be, for any state legislative assembly, it has to be in the range of 60 to 500. This is what the Constitution says. And how this range will be determined? It is determined based on the population of that particular state, which is determined by the Delimitation Commission. And the population that is used for this particular purpose is the 1971 census. And this 1971 census is likely to continue till the first census after 2026. So all these things we have already discussed. So please understand, the number of MLAs from each and every state is not the same. It may vary from state to state, and there are also few exceptions under the Constitution. In some of the state legislative assemblies, the member can even be less than 60 members. Say for example, Sikkim is an example. So they may even be less than 60 members. So provided that exception is provided in the Constitution. So the legislative assembly members of each and every state consist of not more than 450 members. So this is definitely not the case. It can be more than 450, although today we do not have more than 450 members. I think the highest state is the state of Uttar Pradesh, which has got 403 members, but this is not the provision in the Constitution. So this you can safely eliminate. And just to add up on this particular statement, how the members are elected? They are elected by direct election, and what is the principle based on which they are elected? All the members are elected based on the principle of first past the post system. And I hope that you remember what is this first past the post system. And to get elected from a particular constituency, what they all have to do is that they have to secure more number of votes than the other candidates. And there is no electoral quota in this. Come to statement number 2. A person shall not be qualified to be chosen to fill a seat in the legislative assembly of a state if he or she is less than 25 years of age. He or she should have attained 25 years of age. So that is very, very important. So if they are less than 25 years of age, then they are not qualified to contest the election. So this is very much true in case of the legislative assembly. Which one of the statements given above are correct? In case if it is legislative council, he or she should not be less than 30 years of age. So just try to remember this. This is same in case of respectively in Lok Sabha and the Rajya Sabha. Which of the statements given above are correct? While statement 1 is wrong, so the right answer is statement 2. So option 2 is the right answer in this particular case. Okay. So we'll move to the next question. So the next question is related to the anti-defection law. So come to this particular question with reference to the anti-defection law. So we know that this anti-defection law was not part of the original constitution. Anti-defection law was the first time inserted into the constitution by the 52nd Constitutional Amendment Act in 1985 under the leadership of Prime Minister Rajiv Gandhi, and they also simultaneously inserted by this particular amendment the 10th schedule into the constitution, and they have laid down as to what can be seen as defection. There are 4 grounds which were seen as defection under the 10th schedule of the constitution. Anybody who is voting against the party, or anybody who is engaging in anti-party activities, that is, his actions are against the party. And then for an independent candidate, it talks about an independent candidate if he joins any party. And it also talks about a nominated candidate, if any nominated candidate joins any party after 6 months. So in all these categories, the members can be disqualified on the grounds of defection. So what is the punishment for such defection? Is that they can be disqualified, and they can be disqualified during the remainder of the term of that particular house. But even if they are disqualified, they can contest election, because if disqualified, some seats will become vacant, and there can be a by-election. And can they contest in the by-election? Of course, they can contest in the by-election. And who can disqualify them? It is the power of the presiding officer. The presiding officer can disqualify them. But most importantly, is there a time limit within which the presiding officer has to disqualify them? There were few judgments that has been given by the Supreme Court in the form of guidelines that they have to disqualify within a period of 3 months once a petition is filed in front of the speaker. But today there is no such guideline or no such provision in the constitution which explicitly says that they have to be disqualified within certain time limit. So you can say that there is no time limit which is mentioned in the constitution. Now these are all the things that you'll have to remember with regard to the anti-defection law. But in the original constitution, there was an exception for 1/3 split. Sorry, not in the original constitution. By the 52nd Constitutional Amendment Act, there was an exemption for 1/3 split. If there's 1/3 split within the party, it was seen as a faction and it was to be exempted. And this provision was now again amended by the 91st Constitutional Amendment Act in the year 2003. And the 91st Constitutional Amendment Act 2003 said, instead of 2/3 split, now the exemption is only for the 2/3 merger. Okay. So with all these information, let us just try to solve this particular question. Now, what is statement 1 saying? The law specifies that a nominated legislature cannot join any political party within 6 months. Rather, a nominated member can join a political party within 6 months if at all they want to. But they will not be in a position to join after 6 months. So this particular statement would be wrong. Come to statement number 2. The law does not provide, what statement number 2 is saying? The law does not provide any time frame within which the presiding officer has to decide a defection case. So this is very much true. As of now, there is no guideline or there is no time limit in the constitution. So statement 2 is definitely right. Which of the statements given above are correct? So the correct statement is option B. So anti-defection again can be a very important topic. So many issues have happened in the recent past. So just try to revise all the facts before you go to the examination. Come to the next question. Consider the following statements. So statement 1 is saying the Parliament of India can place a particular law in the 9th schedule of the Constitution of India. So what exactly is this 9th schedule? So that is definitely true that the Parliament has a power, because the Parliament has a power to amend the Constitution, and the Parliament has a power to amend the Constitution by virtue of Article 368, and by amending the Constitution, the Parliament can place a law inside the 9th schedule. So all these things are true. Only the Parliament has a power to amend the Constitution in our country as per the Constitution, and then because they have the power to amend the Constitution, they can place a law inside the 9th schedule, because which is very much part of the Constitution. What is the genesis of this Article 9th schedule? It is Article 31B. Article 31B was inserted by the first Constitutional Amendment Act in the year 1951 under the leadership of Prime Minister Jawaharlal Nehru. In fact, the very article was created, that is, this Article 31B is created to provide some form of exception to certain laws, because these laws are considered to be violative of certain fundamental rights, and they were challenged in the courts, and this has been such laws has been struck down by the courts, and that has caused a huge problem to the government with regard to their objective of social justice and to ensure economic justice to the people. And the government was trying to overcome this particular obstacle, and that is when they decided, okay, we'll amend the Constitution and we'll bring in an exception to these laws, and by bringing in this Article 31B. So Article 31B saves the laws which is placed inside the 9th schedule. That is the provision of Article 31B. So it saves from what? It saves exactly from what is called as judicial review. So as per Article 31B, any law that is placed inside the 9th schedule, and once it is placed inside the 9th schedule, it is immune to judicial review. That was the provision when this 9th schedule and Article 31B was placed inside the Constitution. So what is judicial review? This is the power of the courts to look into the action of the legislature and the executives. Now once you take this particular power, any law that is placed inside the 9th schedule cannot be challenged, because it takes away the power of judicial review. So which is not the position today. The position today is that this continued till the IR Coelho case. IR Coelho case in the year 2007. But in the IR Coelho case in 2007, the Supreme Court said you cannot provide blanket immunity. So blanket immunity to the laws which is placed in the 9th schedule is amount to violation of the basic structure of the Constitution, because it is taking away the judicial review. So today the law which is placed inside the 9th schedule is very much challengeable. 9th schedule is very much challengeable. But what is the ground on which it can be challenged? It can be challenged on the grounds of violation of Article 14, 19 and Article 21, because all these fundamental rights are part of what? All these fundamentals are part of the basic structure. So, if the laws which is placed inside the 9th schedule, if they are violative of these articles, that is Article 14, 19 and Article 21, which also is the part of the basic structure, then those laws can be challenged. But however, this is very important. Only those laws which is placed inside the 9th schedule after 24th April 1973 can be challenged, because this is the birth date of the doctrine of basic structure in the Keshavananda Bharati case. So, any law which is placed inside the 9th schedule even today before 24th April 1973, they cannot be challenged in the court of law. So, this is the basic understanding you should have with regard to this particular question. So, statement 1 is definitely right, because the parliament has the power to amend and to place the law inside the 9th schedule. Come to statement 2. The validity of any law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. So, this is not the case. So, validity of any law placed inside the 9th schedule, today can they be challenged? Definitely they can be challenged. So, that is exactly what has held by the IR Coelho case, because see, this question was in 2018. So, today they can be challenged, but however, those laws which is placed inside the 9th schedule on or after 24th April 1973, they can be challenged. Okay. So, the validity of any law placed inside the 9th schedule, okay, so it is cannot be examined by the court and no judgment can be made. So, this particular statement is wrong. So, which of the statements given above are correct? So, the right statement is option, which of the statements given above are correct? So, the right statement is option 1 only. Okay. Again, a very, very important topic. So, please try to revise this before going to the examination. Come to the next question. Question number 106. Look into the question. What the question is saying. Consider the following statements. In the first Lok Sabha, the single largest party in the opposition was the Swatantra Party. So, in fact, the Swatantra Party was not the single largest opposition party. It was a Communist Party of India. So, CPI was the single largest party. They were having around 12 seats, which is very, very nominal in the Lok Sabha. So, in fact, they cannot be recognized as an opposition party, but yes, they were the single largest party in the opposition. So, this particular statement is wrong. Come to statement number 2. In the Lok Sabha, the leader of opposition was recognized for the first time in 1969. Yes, officially it was recognized. Even before that, it was any party which is having more than 10% of the seats in the Lok Sabha were called as the leader of opposition. But officially it was recognized only in 1969. So, this particular statement is true. In the Lok Sabha, if the party does not have a minimum of 75 members, its leader cannot be recognized as the leader of opposition. So, it is not 75 members, but rather it is not less than 1/10 of the members of the total membership of the Lok Sabha. So, you can correlate accordingly. So, today the strength of Lok Sabha is 543. And if you want to have not less than 1/10 of the members with the total membership of Lok Sabha, so accordingly you can correlate, and that would be the size that is required, or the number of members that is required to somebody to be recognized as the leader of the opposition. That's why if you see, both in the 16th Lok Sabha and the 17th Lok Sabha, the government has not recognized anybody as the leader of opposition, because they say that no party is having this particular strength in the Lok Sabha, which is very unfortunate, because for an effective functioning of a democracy, we not only need a stable government, we also need somebody who is strong opposition, so that they can make the government accountable. That's very, very important in a democratic country. So, this is also not the right case. So, which of the statements given above are correct? So, the right answer would be option 2. Option 2 is the right answer. So, all these questions, if you know the basics, you can easily answer these questions. Come to the next question. Consider the following statements. Statement 1. The Rajya Sabha has no power either to reject or to amend the money bill. So, what is this money bill? As you already discussed, money bill is one of the most important financial bills of the government. Money bill is in fact a financial bill, but this financial bill, which is a money bill, shall consist only those subject matters which is mentioned in Article 110 of the Constitution. It shall not deal with any of the other financial matters. So, Article 110 of the Constitution provides for 6 items like taxation, borrowing classes, the appropriation of money from the consolidated fund. If only these subject matters are dealt in a particular financial bill, then this bill can be considered to be a money bill. And these are all most important financial matters. And that's why any money bill can be introduced only in the Lok Sabha, and the procedure says that it can be introduced only in the Lok Sabha. And two important things, second thing is it can be introduced only with the prior recommendation of the president. So the prior recommendation of the president is required, otherwise it cannot be introduced. And once it is introduced in the House, please understand, unlike an ordinary bill, the Lok Sabha and the Rajya Sabha does not have equal powers. Do they have equal powers? No, they do not have equal powers. Where they have equal powers with regard to ordinary bill, but with regard to a money bill, the equal powers are not there. Because again, it is a most important financial matter. So what is the power of the Rajya Sabha in this particular case? The Rajya Sabha can maximum power. What is the maximum power? The Rajya Sabha can maximum delay the passage of this particular bill by 14 days. So the Rajya Sabha cannot reject a money bill. The Rajya Sabha can make some recommendations and send it to the Lok Sabha, but it is not binding upon the Lok Sabha to accept to those recommendations. Or if the Rajya Sabha does not take any action for a period of 14 days, the bill is deemed to be passed in the same manner as it is passed by the Lok Sabha. And it is also very important that you remember that under the constitution, the Speaker of the Lok Sabha has to certify the bill as a money bill before it is being presented to the Rajya Sabha, so that the Rajya Sabha comes to know that it is a money bill. Okay, so these are all some of the ideas and information that you should have. So the Rajya Sabha has no power to either to reject or to amend the money bill. So of course, the ultimate idea is that they do not have the power to amend the money bill because it is not binding upon the Lok Sabha. So that's true. Come to the second statement, the Rajya Sabha cannot vote on demand for grants. So this is also true. So voting on demand for grants during the budget process, which is a particular stage during the enactment of the budget. So this voting on demand for grants is there under Article 114 of the Constitution. So under Article 114 of the Constitution, voting on demand for grants is the prerogative of the Lok Sabha. Only the Lok Sabha can vote on the demands, and during the voting of the demands, the Lok Sabha can introduce certain cut motions as well. So if they are not completely okay with the policy, they can go for a cut motion. They can go for a policy cut motion, or they can go for an economy cut motion. So all these things can be done by the Lok Sabha under Article 114. So the Rajya Sabha cannot vote on demand for grants. So that's also true statement. The Rajya Sabha cannot discuss the annual financial statement. So that's not wrong. So that's not true. So what is annual financial statement? It is budget. In fact, the budget is introduced by the finance minister in the Rajya Sabha also. So the Rajya Sabha can discuss about it. Up to the discussion stage, introduction stage and discussion stage, the things happens in the Rajya Sabha also. So this particular statement is wrong if you say that they cannot be discussed at all. Although they do not have the right to vote in the demand for grants. And the Rajya Sabha does not have much powers with regard to the appropriation bill and the finance bill, which comes at the end of the budgetary process. So all these things are true. But that is not to say that the budget cannot be discussed in the Rajya Sabha. So which of the statements given above are correct? So the right statement is option B, that is 1 and 2 only. So come to the next question. With reference to the union government, consider the following statements. So question number 1, the Department of Revenue is responsible for the preparation of the union budget that is presented in the parliament. So which ministry is responsible? We have already seen that it's a finance ministry. Under the finance ministry, who is responsible? It's not the Department of Revenue, it's the Department of Economic Affairs. So this particular statement is wrong. Statement 2, no amount can be withdrawn from the Consolidated Fund of India without the authorization of the parliament. So this is very much true. Even to take a single penny from the Consolidated Fund of India, it can be taken only by the approval of the parliament in the form of an appropriation bill. And that is exactly is the idea behind parliamentary democracy. In a parliamentary democracy, how the executives are controlled? For every action of the executive, for every money that they spend, they are accountable to the parliament. And the authorization has to be given by the parliament in the form of an appropriation. And once a budget is passed, if they again need some money, they can make use of the supplementary grants and the additional grants. And then also they need the approval of the parliament in the form of an appropriation bill. So this particular statement is very much true. Statement 3, all the disbursement made from the public accounts also need the authorization of the parliament. If you see that majorly in our country, the constitution provides for 3 types of funds. One is the contingency fund of India, which is the most important fund because all the resources of the government, all the revenues that they generate, they get all the taxes that they collect, all the profits that they make from PSUs, whatever is the revenue of the government that gets credited into the consolidated fund, which is the major source of revenue. Apart from that, there is also something which is called as a contingency fund. The contingency fund is like an impressed fund. It cannot meet out the expenditure of the government, but if there is a sudden need for any expenditure, say there is a disaster or something, suddenly you will have to take out money. So you cannot take out money from the contingency fund of India immediately because you have not thought about this during the enactment of budget. Or probably that even if you have to take out the money, you need the approval of the parliament from the contingency fund of India, which is a very time consuming process. So what has been done is, during the budgetary process itself, you will take out some money from the contingency fund and you will place it inside the from the consolidated fund, and you will place it inside the contingency fund. This will happen during the budgetary process. And once you place it in the contingency fund, when there is an immediate urgency, when there is an emergency, you take out money from the contingency fund with approval of the president, which the president have delegated to the secretary, Ministry of Finance, or the secretary, Department of Revenue. So on behalf of the president, these officers can have this power. So on the executive order or the direction, this money can be taken out. So this is basically what is the contingency fund of India. And then you have one more fund which is in the nature of the public accounts of India. The public accounts of India is also controlled by the government of India, but the government of India is only a trustee to this particular fund. So please understand. So this is not a fund that is owned by the government itself. The government is just a trustee. That means the fund which is getting credited into this particular, the money that is getting credited into this particular fund is the money of the people themselves. Say for example, the pension funds of the people, the post office savings and the interest and all those things probably might get credited into these funds. So the government is only a trustee, and whenever the people need, they may take out this particular money according to the relevant rules and all those things. So this is done by an executive action. So there will be an appropriate officer who can permit the people to take out money. So only an executive action is required to take out money from the public accounts of India. So all disbursements made from the public accounts also needed the authorization of the parliament. So this is definitely wrong statement. Which of the statements given above are correct? So the right answer for us is only the option C. In my opinion, it's a very, very important topic. You should have a very clear understanding as to what is the consolidated fund, what is the contingency fund, and the public accounts of India, especially where the authorization of parliament is required. The authorization of parliament is required only with regard to the consolidated fund of India. Come to the next question. So consider the following statements regarding the no confidence motion in India. I think we have already discussed this. The no confidence motion is very, very essential in a parliamentary democracy because the political system of India is based on the parliamentary democracy. And in a parliamentary democracy, what is very essential is that the government that is there in power should always have a majority in the parliament. And to be very specific, in India, the majority has to be there in the Lok Sabha. And without this majority, the government cannot function. So, okay, at the time of formation of the government, the majority is checked. But how do you know that this majority is always maintained in the house? So, how do you ensure that this is happening in the house? And that's why under Article 118 of the Constitution, the power has been given to the Lok Sabha to make their own rules to carry out their proceedings. And Article 118 along with Article 75, which talks about the collective responsibility. So, the collective responsibility means that the Council of Ministers shall always be collectively responsible to the Lok Sabha, which also means that they should always have a majority. Under Article 118, they can make rules. So, the Lok Sabha has made a rule, rule number 198. So, under rule number 198, any member of parliament in the Lok Sabha can introduce this particular motion. There is no need to specify as to why he is introducing this particular no confidence motion. Without specifying the reason, they can introduce that with the permission of course, the speaker, provided 50 members support this introduction of this particular motion. Once the speaker allows for it, then there can be a discussion and then the motion is put to vote. And if the motion is passed with a simple majority, then it is assumed to be a vote of no confidence motion, or in other words, that the government is not having the majority. In this particular case, the government has to resign. So come to the first statement. There is no mention of no confidence motion in the Constitution. This is very much true. There is no mention. So the only thing that we should remember under the constitution is Article 75, which provides for collective responsibility, and Article 118, where the houses can make their own rules. So this is the understanding that you should have. And the word no confidence is only mentioned in Rule 198 of the Lok Sabha. And this no confidence motion cannot be introduced in the Rajya Sabha. Why? Because under the constitution, the Council of Ministers are collectively responsible to whom? They are collectively responsible only to the Lok Sabha and not to the Rajya Sabha. Come to statement number 2. Any motion of no confidence can be introduced in the Lok Sabha only. So this is very much true. Now please understand, I have already said that 95% of the cases, if there is an extreme statement or if they use the word only, that it may be a wrong statement. But here it's a right statement. So you'll have to understand all these things. So the motion of no confidence can be introduced only in the Lok Sabha. So which of the statements given above are correct? So the right answer is both 1 and 2. Very, very important. So please pay attention to such topics before you go to the examination. Come to the next question. Consider the following statements. An amendment to the Constitution of India can be initiated by an introduction of bill in the Lok Sabha only. So here only is wrong, which I think we already discussed with regard to this constitutional amendment under Article 368. So I am not getting much of discussions with regard to this, because under Article 368, it can be introduced in either houses, not necessarily in the Lok Sabha. So this particular statement is wrong. Up to statement number 2. If such an amendment seeks to make changes in the federal character of the Constitution, so what is the federal character of the Constitution? So few of the provisions are mentioned in Article 368 itself, like the election of the president, the 7th schedule of the Constitution. So in general, what is a federal provision? A federal provision is something, if you amend that particular provision, it is going to alter the power balance between the center and the state, or in other words, you can say it is going to change the power that has been given between or shared between the center and the states. So such provisions are called as the federal provisions. So in case if an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislature of all the states in India. So it is not required to be ratified by all the states, but it requires a ratification of not less than half of the states. So it is not even more than half of the states, it is not less than half of the states, which means even if exactly half number of states are approving this particular amendment, then it will go to the president assent. So that is the understanding, and the states have to ratify them with simple majority. So the state has to ratify them with simple majority. And what is the time limit for the states to ratify them? Under the Constitution, there is no explicit time limit. So as long as the states do not ratify, then it may not go to the president for the assent. Which of the statements given above are correct? So here it is not all the state legislature, that would be wrong. So the correct statement would be neither 1 nor 2, because both the statements are wrong. So we'll quickly move to the next question. What will follow if a money bill is substantially amended by the Rajya Sabha? Nothing will happen if the money bill is substantially amended, because whatever amendment that they make and they send it back to the Lok Sabha within 14 days is not binding upon the Lok Sabha. Because with regard to a money bill, what is the maximum option that the Rajya Sabha might have? That they can delay the passage of the bill by 14 days, nothing more than that. So just have this understanding. So money bill, the power of the Lok Sabha and Rajya Sabha, the procedure for a money bill, very, very important. See how many years this question is getting repeated year after year. So in this case, what is the answer? The Lok Sabha may still proceed with a bill accepting or not accepting the recommendations of the Rajya Sabha. So the right answer is option A. A is the right answer. Come to the next question. Consider the following statements. Okay, now we are done with the legislature part. So we will move on to the judiciary. So again, what is the expectation from the judiciary? The judiciary, you can expect 1 question definitely, probably 2 questions also in the preliminary examination. Now before we go on to judiciary, just let us try to summarize the topics that you have seen with regard to the legislature. Now see, legislature, every year there is possibly a question from the constitutional amendment. So be very clear about Article 368, the procedure, what is a federal provision, and in case of federal provision, what is the majority that is required, how the procedure is a little different. Can a constitutional amendment bill be introduced by a private member, in which house it can be introduced? So entire Article 368 is very important. See the budget, there is a question from budget. You should be generally aware of what is budget, where the budget is introduced, and the various process in the budget, what is demand for grant, what is a charge expenditure, what is a made expenditure, what is vote on account, what is vote of credit, what is the various grants, supplementary grants, the additional grant and all those things. And then come to the topic of various funds. You should be clear about the concept of what is consolidated fund, what is contingency fund, and what is public accounts of India. Come to money bill again. So you should be in general aware of what is money bill and what is a finance bill and what are the differences between them. The next topic is the presiding officer. So see the number of questions that has come from the presiding officer, the speaker, the deputy speaker, the chairman, the deputy chairman. So what will happen if they are absent? What will happen when there is a vacancy? To whom they will submit the resignation? So what are their powers and functions? So all these areas are very, very relevant for the examination. You may also check as to what is or who is a pro tem speaker. And then look into the sessions of the parliament, especially under Article 85, what is the power of the president to summon the session, what is prorogation, what is dissolution. So again, these topics very important. And there is also one more important topic which is related to the parliamentary committees. And there are every year possibly there's a question from the parliamentary committee, especially with regard to the standing committees and with regard to the financial committees. So please pay attention to these committees. And apart from that, we have also seen certain other areas as well. So try to be very clear about these areas. Don't miss out on these areas. Now we'll go to the judiciary. So we'll also try to understand how the questions are coming. So sometimes the questions come based on what is there in the current events, and accordingly the relevant provisions in the constitutions may be asked in the examination. So that's why it's also very important that you keep a tab of what happened in the current affairs. So further clarification and for further idea, you may also have a look into the 100 most important topics that you already done, and that series of 10 lecture is already there in the StudyIQ English channel. Come to the next question that is related to the judiciary. Statement 1. So this question is related to the contempt of the court. So let us try to understand from statement 1. Pursuant to the report of Hutchins-Sanyal Committee, the Contempt of Court Act 1971 was passed. So before I get into this particular statement, what does it mean by the contempt of the court and what the constitution says regarding this? Is there any law with regard to the contempt of court in our country? So all these questions has to be answered. And for which first we'll have to understand Article 129 of the Constitution. Article 129 of the Constitution says that the Supreme Court is a court of record. And the Supreme Court, by virtue of being court of the record, and if anybody is showing any kind of disrespect towards the authority of the Supreme Court or the orders that is passed by the court, then the Supreme Court can issue a notice of contempt. And the Supreme Court can punish the individuals or the institutions which is showing contempt towards the Supreme Court under Article 129 of the Constitution. So this is what Article 129 says. And a similar power is also given to the High Courts under Article 215 of the Constitution. So there is also contempt powers to the High Court under Article 215. But then the biggest problem is what is contempt has not been defined. So contempt is generally seen as a sign of disrespect towards the authority of the court. But what exactly is the definition is not defined. But the Constitution gives the power to the Parliament to make a law and to define and to regulate the procedures of the contempt. So in order to make this particular law, the government of India in 1961, they appointed a committee which is called as the Hutchins-Sanyal Committee. And at that point of time, he was the Solicitor General of India. Solicitor General of India. 1961, under his leadership, a committee was formed to recommend the government as to how to make a law with regard to the contempt of the court, because such a provision is there in the Constitution. And the Hutchins-Sanyal Committee recommended that to make a law and to allow for the procedures as to how to punish the individuals in case of contempt. So accordingly, these recommendations were accepted by the government, and subsequently they enacted this Contempt of Court Act 1971. So today the contempt is nowhere defined in the Constitution. Also the contempt powers are given to the Supreme Court and High Court, but what amounts to contempt is not defined. It is only defined only in the Contempt of Court Act 1971. If you see the Contempt of Court Act 1971, Contempt of Court Act 1971, it defines contempt into civil as well as the criminal offence. So there is a civil contempt as well as a criminal contempt. So basically there is a difference between what is a civil and a criminal contempt. So civil contempt is a milder form of contempt where anybody shows any disrespect or willful disobedience, rather you can say willful disobedience towards an order of court or a summon which is issued by the court. So all these things can be seen as civil contempt. And what is a criminal contempt? A criminal contempt is something where the individual is trying to malign the reputation of the institution of judiciary, or by his actions, or an individual is trying to prejudicially affect the administration of justice by the court. In all these cases, the court can see that the gravity of this particular offence is much higher, and then it can be seen as a criminal contempt. And this is what the Contempt of Court Act says. So please understand, what is contempt is nowhere defined in the Constitution, but only in the Contempt of Court Act. And also in the procedure of the Contempt of Court Act, if the court has to issue the contempt notice upon any individual or institution, so first of all, it has to be approved by the Attorney General of India or by the Solicitor General of India, and then only the contempt notice can be taken, although nothing restricts the Supreme Court and High Court to issue suo motu notice also, but mostly this is the procedure that they have to follow. So with this, come to the question. Pursuant to the report of Hutchins Annual Committee, the Contempt of Court Act 1971 was passed. So this is true. Statement 2, the Constitution of India empowers the Supreme Court and the High Court to punish for the contempt of themselves. This is true by virtue of Article 129, Article 215 along with the Contempt of Court Act 1971. So this particular statement is true. Statement 3, the Constitution of India defines civil and criminal contempt. This is wrong. The Constitution doesn't define civil and criminal contempt. It is only defined in the Contempt of Court Act 1971. In India, the Parliament is vested with the powers to make laws on the contempt of court. So this is also true. So which of the statements given above are true? So the right answer is option B, that is 1, 2 and 4 only. Now please understand that on the one hand, the Constitution is providing the right to freedom of speech and expression, where the individuals can express their ideas, thoughts and their viewpoints in whichever way that they want. But however, at the same time, this very right to freedom of speech and expression is also restricted on the grounds of the contempt of the court. Because contempt of the court is seen as a very, very serious thing in a democracy, because unless and until the judges are free to pass their orders, and if they are subject to a lot of criticism, unnecessary criticism or a motivated criticism, then they will not be able to perform their duty effectively. And that's why that this contempt of court is even a reasonable restriction on the right to freedom of speech and expression. Does it mean that in every case of contempt then the individuals will be punished? So the judiciary itself has given certain guidelines. Any liberal criticism or any original factual criticism or any factual report against the order of the court may not be seen as a contempt of the court. So some element of liberty is there with regard to criticizing the courts, but you cannot disregard the authority of the court completely, or you cannot prejudice the administration of justice by the courts. That's not allowed. So the right answer in this particular case is option B. Okay, so come to the next question. With reference to the Indian judiciary, consider the following statements. Any retired judge of the Supreme Court of India can be called back to sit and act as the Supreme Court judge by the Chief Justice of India with a prior permission of the President of India. So this is true. They can be appointment of the ad hoc judges, because if matters in the court is much higher and then they do not have sufficient judges, in this particular case, the Chief Justice of India with a prior approval of the President, it can be done. So such a provision is provided under Article 128 of the Constitution. So it is very much, it can be done. Consider the statement number 2. A High Court in India has the power to review its own judgment as the Supreme Court does. This is also true, but the only difference is the Supreme Court of India has been given this power under the Constitution itself. So under the Constitution itself, they have the power which is given to them by virtue of Article 137. So this Article 137 is in case of the Supreme Court. So under Article 137 of the Supreme Court has a power to review its own judgment, because the Supreme Court is the highest court of the land. And in case if there is a judgment, if there is an error in the judgment, there has to be some mechanism to review all those things. So this power is given to the Supreme Court under Article 137. And the Supreme Court went on to further expand the scope of this Article 137. They not only said that they have the review powers, on top of the review powers, they can also have the curative powers. So there can be a curative petition also. So all these things are flowing from the Constitution itself. So what is the case with regard to the High Courts? The High Courts also have the power to review their judgments, but not by the Constitution, but by the statute. So this review power is given to the High Court through the Civil Procedure Code. The Civil Procedure Code allows the High Court to review their judgment, because you also understand that in case of the High Courts, the Constitution does not elaborately deals with regard to the jurisdiction, except for the writ powers and the supervisory powers of the High Courts. Most of the powers of the High Courts are derived from the existing laws in our country. So accordingly, the Civil Procedure Code gives them the power to review. So this is also very much true. So which of the statements given above are correct? So in this case, both statement 1 and 2 is correct. So the right answer would be option C. Option C is the right answer. Both 1 and 2 are the right statements. So consider the following statements. Come to the next question. That is question number 114. The first statement is the 44th Amendment to the Constitution of India introduced an article placing the election of Prime Minister beyond the judicial review. In fact, this is not by the 44th Constitutional Amendment Act. So the statement is true, but not with the, happened with 44th Constitutional Amendment Act. It has happened by the 39th Constitutional Amendment Act in 1975. So this has happened during the emergency time, for which we'll have to have an idea as to what is this Raj Narayan case. I'm not going to explain this Raj Narayan case, but it is one of the important cases in the history of India where Mr. Raj Narayan challenged the election of Prime Minister Indira Gandhi. And subsequently, the historians say this is one of the reasons as to why the national emergency was proclaimed in 1975, following the outcome of this particular case. In the Raj Narayan case, the Allahabad High Court declared the election of Prime Minister Indira Gandhi to be null and void, because in the opinion of the Allahabad High Court, she has engaged in the corrupt practice under the Representation of People Act. And subsequently, the matter has gone to the Supreme Court. When the matter was pending in the Supreme Court, a constitutional amendment was carried out by the Parliament, and that constitutional amendment is the 39th Constitutional Amendment Act, which happened in 1975. And by this 39th Constitutional Amendment Act, they said that the Prime Minister, the election of Prime Minister, not only the Prime Minister, the Speaker, the Vice President, the President, all the election disputes are outside the purview of the courts. That means the court cannot look into these disputes. And who will look into these disputes? Under the 39th Constitutional Amendment Act, the Parliament will have a power to enact a law, and the Parliament will determine an appropriate authority. It can be a tribunal or any of the other authorities. Only those authorities can look into this particular dispute. So, but however, the Supreme Court was not happy with this particular 39th Constitutional Amendment Act. So this 39th Constitutional Amendment Act was struck down by the Supreme Court in the Raj Narayan case. When the matter subsequently came to the Supreme Court, it said that the 39th Constitutional Amendment Act is violative of the basic structure. You are trying to take away the power of the courts. Adjudication is a power of the courts, and if you are trying to take away the power of the courts, you are tinkering with the concept of separation of powers. You are tinkering with the concept of separation of powers, which is part of the doctrine of basic structure, and thereby we cannot allow you to take away the basic structure which has been held by the Supreme Court in the Keshavananda Bharati case in 1973. Stating this, the Supreme Court declared this particular provision to be null and void. Okay. So with this information, just try to come to this particular statement. The 44th Amendment to the Constitution of India introduced an article placing the election of Prime Minister beyond the scope of judicial review. It is not 44th, but it is 39th. So this particular statement is wrong. The Supreme Court of India struck down the 99th Amendment to the Constitution of India as being violative of independence of judiciary. So this is very much true. The 99th Constitutional Amendment Act was trying to replace, it in fact amended certain articles, including Article 124, Article 217 of the Constitution, which deals with today the appointment of judges of the Supreme Court and High Court, which was at the time was in the hands of the Collegium, and even today it is in the hands of Collegium. But this amendment was trying to change the power which is there in the hands of Collegium to the National Judicial Appointments Commission, NJAC. And they are trying to give the power to the National Judicial Appointments Commission, and which was struck down by the courts, saying that if you are giving the power to the NJAC, which also has people outside the judiciary, and outside the judiciary, this NJAC is a group of people, and these people will recommend the names to the president as to who would be appointed as the judges of the Supreme Court and High Court, and also the transfer of judges of the High Courts. All these things will go to NJAC, which the Parliament amended and brought in the year 2014 by the 99th Constitutional Amendment Act. And this NJAC is supposed to have 6 members, including the judiciary, executive, and certain people outside, and the common people who are part of the public life, who have done exceptional service. But they were given some veto powers. They can veto the decision that is taken by the judges. So this veto power that is given to the people outside the judiciary, the Supreme Court thought that it would violate the independence of judiciary, and they declared independence of judiciary to be part of the basic structure. And by saying that, this 99th Constitutional Amendment Act was also struck down by the judiciary. So the Supreme Court of India struck down the 99th Constitutional Amendment, 99th Amendment to the Constitution of India as being violative of independence of judiciary. This is true. So they have struck down this particular thing. So which of the statements given above are correct? So while statement 1 is wrong, statement 2 is right. So the answer is option B only. But in both the cases, what is the doctrine on which the Supreme Court has struck down the respective amendments? Is on the doctrine of basic structure. And this year is the 50th year after the Keshavananda Bharati case has happened. So it is very important that you are completely aware of as to what this doctrine is. So probably you may expect a question in the mains examination also, which would be more analytical, but probably in the prelims examination, it will be more fractional in nature, if at all a question is coming. Come to the next question. Consider the following statement. So this is with regard to the removal of the judges. If you see the removal of the judges, you will have to understand Article 124 of the Constitution, which talks about the removal of the judges. So what is Article 124 of the Constitution is saying? Article 124 of the Constitution is saying, if at all the judges has to be removed, how they can be removed? They can be removed. So how they can be removed is that a motion has to be passed for the removal of the judge, and this motion has to be passed in both the houses. It has to be passed where? It has to be passed in both houses. It has to be passed in both houses, and it has to be passed with what majority? It has to be passed in both the houses with special majority. And once it is passed with special majority in both houses, then it has to be approved by the president. It has to be approved by the president. And all these things has to happen in the same session in which the motion is introduced in the first house. So all these things are very important, and on top of this, Article 124 of the Constitution says that the motion can be introduced on the grounds of what? It can be introduced on the grounds of misbehavior or incapacity. So this is the ground on which it can be introduced. So this is the only thing that is mentioned in the Constitution. And here the special majority would be same as that of the constitutional amendment. So it has to satisfy two conditions, that is not less than 2/3 of the members present and voting, and the absolute majority of the house. So this is the detailed, I won't say it's a detailed process, this is a major step that is given in the Constitution. But the biggest problem under the Constitution is what constitutes misbehavior and incapacity is not defined. And in order to determine as to what constitutes misbehavior and incapacity, and the various procedural things as to how it can be determined, is to be determined by an act of parliament. So Article 124 of the Constitution gives a power to the parliament to make enact a law, and by that law to determine a procedure as to how this may be determined. So accordingly, the parliament has enacted what is called as the Judges Enquiry Act 1968. So this actually provides for the procedure as to what constitutes misbehavior and incapacity. So initially, when the motion is introduced, a 3-member committee is usually set up by the presiding officer in whichever house it is admitted, and these 3-member committee may consist of a judge of a Supreme Court, a Chief Justice of High Court, and a distinguished jurist, and they will inquire and they will try to find out whether there is misbehavior or incapacity on the part of the judge. So with this information, come to the question. The motion to impeach a judge of a Supreme Court of India cannot be rejected by the Speaker of Lok Sabha as per the Judges Enquiry Act. This is wrong. Under the Judges Enquiry Act 1968, the presiding officers have the discretion to accept or not to accept the motion. For example, few years back, when the opposition-led parties, when they were trying to introduce a motion against then Chief Justice of India, Justice Deepak Mishra, that motion was rejected. It was not even introduced by then chairman of Rajya Sabha. Mr. Venkaiah Naidu was the chairman of Rajya Sabha. He rejected it. So they have the discretion because he was satisfied this is a motivated step, and hence he rejected it. So this particular statement is wrong. Come to statement number 2. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges. So this is not true. In fact, that is why there is an inquiry committee which will be appointed by the presiding officer of that particular house in where the motion is introduced, and they have to conduct the inquiry and find out whether there is a misbehavior or incapacity. Come to statement number 3. The details of the process of impeachment of the judges of the Supreme Court of India are given in the Judges Enquiry Act. So this is true. It is given in the Judges Enquiry Act. If the motion for the impeachment of the judge is taken up for voting, the law requires a motion to be backed by each house of the parliament and supported by a majority of the total membership of that house and by not less than 2/3 of the members present and voting. So this particular statement is very much true. Which of the statements given above are correct? So the right answer is 3 and 4 only. So option C is the right answer. Okay. So let's move to the next question. With reference to the Constitution of India, prohibition or limitation on the provisions contained in the ordinary laws cannot act as prohibition or limitation on the constitutional powers under which article, under Article 142 of the Constitution. It could mean which one of the following. So we'll have to understand as to what is this Article 142. Article 142 has been sometimes in the news, and this Article 142 and the power of the Supreme Court under Article 142 has been asked at least once or twice in the last 10 years. So very important again. So what is this Article 142? You can say this is an extraordinary power. It's an extraordinary power in the hands of the Supreme Court. Now, why do you say this as an extraordinary power? Now, please understand, when the trial is happening in any court, for that matter, the courts have to give punishment according to the outcome of that particular trial. And also what the law prescribes. The court normally cannot give them the punishment if the law prescribes that the maximum punishment is 5 years. They cannot give them a punishment of 10 years. That's not possible. But however, in certain cases, and please understand, this is only the power of the Supreme Court and not any of the other courts in our country. The Supreme Court has got this extraordinary power under Article 142, which means the Supreme Court is not constrained in its action by the ordinary laws of the land, and the Supreme Court can go beyond the ordinary law of the land in order to ensure complete justice in certain matters. If the Supreme Court finds that I'll have to pass certain orders, although there is no law that authorizes me to do that, but in order to ensure complete justice to the victim in this particular case, I have to go beyond the ordinary laws of the land, and then I have to pass this particular order. So thereby I can ensure justice to that particular victim or to that particular individual. So this power is there to the Supreme Court under Article 142. The recent exercise of this power by the Supreme Court was in the A.G. Perarivalan case. Although can be little controversial, but let us not get into that particular controversy. But the Supreme Court has exercised its power under Article 142, and it has released A.G. Perarivalan from the jail. So who is this A.G. Perarivalan? He is one of the convict in then Prime Minister of India, Mr. Rajiv Gandhi assassination case. And today A.G. Perarivalan is out of the jail because the Supreme Court of India has exercised its power under Article 142 of the Constitution, and in order to ensure complete justice to Perarivalan, who was already in jail for more than 31 years, has been released from the jail. Although there is no such law that gives the power to the Supreme Court, but the Supreme Court has exercised this particular power, stating that the governor should have remitted the punishment of A.G. Perarivalan on the recommendation of the State Council of Ministers, while the governor was sitting on top of this particular thing. And in order to ensure complete justice and seeing the conduct of A.G. Perarivalan over the period of years, who have completed multiple degrees and he has been writing number of books, and he was very young when he was convicted, and then I think one of the officers who conducted the inquiry from the CBI came out openly and he has submitted the report also in the court that there was some kind of misinterpretation of the statement that was given by A.G. Perarivalan. So there's a possibility that he is innocent in this particular case. So anyways, the Supreme Court has used this extraordinary power under Article 142 of the Constitution, and they have released A.G. Perarivalan from the jail. So in this particular context, what is this Article 142? The Supreme Court of India is not constrained in the exercise of its powers by the laws made by the Parliament. What is statement A? The decision taken by the Election Commission of India nowhere related to Election Commission of India. The event of great financial crisis in the country nowhere related to article. This article is related to the financial crisis. It is also nowhere related to the state legislature. So the right answer is Option B. Come to the next question. With reference to the Constitution of India, consider the following statements. No high court shall have the jurisdiction to declare any central law to be constitutionally invalid. So this is completely a wrong statement. Now please understand, in India we have an integrated judiciary. When we say that we have an integrated judiciary, we do not have a parallel judiciary as in United States of America, where there is a separate courts to look into the federal laws and there is a separate state courts to look into the state laws. We have an integrated judiciary. So the high courts can very well look into the validity of the central law. Recently, the Madras High Court declared some of the provisions of Prevention of Cruelty to Animals Act as unconstitutional, which means that the Prevention of Cruelty to Animals Act is a central legislation but has been challenged in the Madras High Court. So this is very much possible. In number of states, the Hindu Marriage Act has been challenged, the Special Marriage Act has been challenged in various high courts. These are all laws enacted by the parliament. So of course, the laws enacted by the parliament can be challenged in the high court. But then the only problem is practically, what if the law is struck down by the high court because the high court's jurisdiction is only within the particular state. In all these cases, it is very natural that the central government, which is a party to this particular case, because of course the central government and the parliament has made this particular law, so they are party, naturally a party to this particular case, they may go for an appeal in the Supreme Court and subsequently the matter will be taken up by the Supreme Court and the Supreme Court can pass the order and settle the issue. Because the order that is delivered by the Supreme Court is applicable throughout the territory of India. But otherwise, you cannot say that the high courts cannot look into the constitutional validity of a central law. That is wrong to say it like that. Statement 2. An amendment to the Constitution of India cannot be called into question by the Supreme Court. Then who is to question the constitutional amendment? In fact, it is the responsibility of the Supreme Court of India, which is a constitutional court in our country, to take up all these matters. Okay, so this particular statement is also wrong. But however, what is the ground on which the constitutional amendment can be challenged in the Supreme Court? It can be challenged on the ground that it violates the doctrine of basic structure. Okay, so this particular statement is also wrong. Which of the statements given above are correct? So the correct statement would be, in this case, both the statements are not correct. So the answer is neither 1 nor 2. Come to the next question. In India, the judicial review implies. What does the judicial review implies? Now, judicial review is a very, very important thing, and this judicial review has already been declared to be part of the basic structure. So, the courts in our country have the judicial review, especially the Supreme Court under Article 13, Article 32. Similarly, the High Courts under Article 226, Article 227. So, in all these cases, they exercise some element of judicial review. So, what is the power of judicial review? It is the power of the courts to look into the actions of the other two organs of the state. That is the legislature and the executive, and ultimately the judiciary has to ensure that the other two organs of the state carry out their function in accordance with the provisions of the constitution. They have to see any law that is made by the parliament, is it violative of the constitution. They have to see any action that is done by the executive, is it violative of the constitution. And then by using their power of judicial review, they can declare these actions to be void, or to say that these actions will have no legal effect and it is null and void. But however, what we will have to understand is, can the Supreme Court declare any action to be null and void just because the Supreme Court feels that it is wrong on the part of the legislature or the executive? Can they just look into the wisdom, what is right and what is wrong in their opinion of a particular action of the legislature and the executives? So please understand, the judiciary is not supposed to declare any action to be null and void just merely on the ground that they feel that it is wrong on the part of the executives. The judiciary is not supposed to judge the wisdom of the executive or the legislature. The judiciary is supposed to see only if the law is violative of the constitution or not. The law can be a bad law, but as long as it does not violate the constitution, the Supreme Court cannot declare that laws to be null and void. If the Supreme Court tries to do that, then it can be considered to be judicial overreach or judicial adventurism. So that is not what is considered to be judicial review. Judicial review is strictly based on what is laid down in the constitution. So come to the statement. The power of the judiciary to pronounce upon the constitutionality of laws and the executive orders. So this is very much true. The power of the judiciary to question the wisdom. They are not supposed to question the wisdom. Okay, so they are just to see whether the actions are in line with the constitution or not. The power of the judiciary to review all the legislative enactments before they are assented. In fact, the legislative enactments cannot be checked or cannot be challenged before they are assented and before they are passed by the president. And the last thing is the power of the judiciary to review its own judgment, to give review its own judgment given earlier in similar different cases. This is not judicial review. This is just the review powers of the courts. There is a review power to the courts under Article 137 of the Constitution, which I have already seen, but judicial review is what is given in option E. Okay. So come to the next question. So we will move on to question number 119. The power of the Supreme Court of India to decide disputes between the centre and the states falls within what? So this is something that we have elaborately discussed, and you may also look into the 100 most important topics where we have elaborately discussed about the various jurisdiction of the courts, and most importantly the dispute related to the centre-state relationship. So any dispute between the centre and the state falls under the original jurisdiction of the Supreme Court under Article 131 of the Constitution. But please understand what kind of disputes will fall under Article 131 of the Constitution. Only the federal disputes. Only the federal disputes fall. So what is a federal dispute? Any dispute between centre versus state, any dispute between state versus state, any dispute between centre and the state or states on one side versus the other state or states on the other side. So all these things are considered to be the federal dispute. Recently there was a dispute with regard to some of the villages, border dispute between Maharashtra and Karnataka. So the matter is already filed in the Supreme Court under Article 131. That's a dispute between state versus state. Any dispute between centre and the state, say for example when the farm laws were passed by the parliament, which is now repealed anyways, those farm laws were challenged by some of the state governments like West Bengal, Punjab, Kerala. They have challenged those farm laws, and these laws were challenged in the Supreme Court under the original jurisdiction. So the right answer is option C. Very, very important area. You will have to understand as to what is a federal dispute here. Come to the next question. The power to increase the number of judges in the Supreme Court in India is vested under. So again, for which you will have to understand Article 124 of the Constitution. The power to increase the number of judges in the Supreme Court is vested in the Parliament. So the Parliament has a power to do that. In the original Constitution, if you see under Article 124, it says that the number of judges shall be 7 plus 1, 7 Pusain judges and 1 Chief Justice of India. But the Constituent Assembly knew that these number of judges may not be sufficient, as and when there are more number of litigations and as and when the cases increase, probably you will have to increase the number of judges. But they have given this power to whom? They have given this power to the Parliament. So under the Constitution of India, under Article 124, the Parliament by a law, they can increase the number of judges. And using this power, the Parliament has subsequently made a law, and this law has been amended now number of times. Today, as of today, what is the strength of the Parliament? It is 33 plus 1. You have 33 judges in the Supreme Court and 1 Chief Justice of India. So overall there are 34 judges. That's a present strength. But tomorrow can it be increased? Of course it can be increased by an ordinary law of the Parliament. They have to exist. They have to amend the existing law and they can make the change. So the power is there in the hands of the Parliament. And we will not only be aware of as to who can determine the strength of the judges of the Supreme Court. So now the question comes, who is going to determine the strength of the judges in the High Courts? And for the High Courts, please understand, the power is not there in the hands of the Parliament, but for the High Courts, it is there in the hands of the President of India. So the President can make an order, and by that order, he can increase the strength of the various High Courts. Okay. So please have an understanding of this as well. Come to the next question. So we'll try to cover another 5 questions before we complete this session. So which of the provisions, what is the provision to safeguard the autonomy of the Supreme Court of India? And which means to say, what are the various provisions in the Constitution that tries to safeguard the autonomy of the Supreme Court? 1. While appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. This is very much true. If you look into Article 124 of the Constitution, it says that the President shall consult the Chief Justice of India and such other judges as he may deem necessary before making the appointment of the Supreme Court. But today we know practically what happens is the collegium system. But anyways, whatever is there in the constitution is exactly this. So this is very much true. And it is not only the consultation today. This consultation would amount to concurrence as per the second and the third judges case. Statement 2. The Supreme Court judges can be removed by the Chief Justice of India. No, the Supreme Court judges cannot be removed by the Chief Justice of India. The Supreme Court judges can be removed only by a motion that is passed in both houses of the parliament, then approved by the President of India. So just now we have seen as to how they can be removed. The salaries of the judges are charged on the Consolidated Fund of India, to which the legislature doesn't have to vote. So this is very much true. The salary of the judges of the Supreme Court are charged upon the Consolidated Fund of India. So here if it is Supreme Court, then it is true. But suppose if it is the salary of the judges of the High Court and the pensions of the judges of the High Court, maybe not the true case. The salary of the judges of the High Courts are charged upon the Consolidated Fund of the respective states. Okay. So that is not true. But however, the pensions of the judges of the High Court are charged upon the Consolidated Fund of India. So see whether it is salary or the pensions. So statement 3 is wrong. Statement 3 is right. And then when you say charge expenditure, so charge expenditure means that there is no need to vote, although it can be discussed during the vote on demand for grant stage. It is not voted in the Lok Sabha. All appointments of officers and staff of the Supreme Court are made by the government only after consulting the Chief Justice of India. So this is not true. Under Article 146 of the Constitution, all the appointments, the staffs of the Supreme Court are appointed by the Chief Justice of India or by any of the other judges the Supreme Court may decide. So not by the government. Okay. So this particular statement is wrong. Which of the statements given above are correct? So the right statement would be 1 and 3 only. Again, very, very important. So to have a better understanding of the collegium and all those things, you can look into the 100 most important topics. We elaborately dealt a question with regard to the collegium, what is the genesis of collegium, how it has subsequently unfolded in the different judges cases. So you may refer to the 100 most important topics that you have discussed. Come to the next question. Which of the following are included in the original jurisdiction of the Supreme Court? So any dispute between the government of India and one or more states, definitely true, because we have seen this is a federal dispute. And such disputes may go to the Supreme Court under the original jurisdiction under Article 131. A dispute regarding the elections of either house of the parliament or that of the state legislature. So this is not under the original jurisdiction. So in all these cases, these disputes can go only to the High Court concerned, where they got elected. And probably they can go to the Supreme Court by a way of an appellate jurisdiction of the Supreme Court and not under the original jurisdiction. So this particular statement is wrong. Any dispute between government of India and union territory. So many students might think that yes, this is the right statement, but this is not right. Any dispute between union government and the union territory is not a federal dispute in the first place, because union territory is administered centrally by the President of India by virtue of Article 239. So why the name union territory? It is a territory of the union. It is administered by the union. It is within the union government. Although they may have certain special status, but it is not in a federal relationship. Unlike the states, it is not in a federal relationship. So in all these cases, the dispute may not directly go to the Supreme Court. It will go to the High Court concerned, and then probably by way of an appeal, they can go to the Supreme Court and not directly. Any dispute between two or more states, so this is definitely a federal dispute. So what is the answer in this particular case? The answer is option 1 and 4. Very, very important question. So please remember this particular concept. Do not make a mistake in case if this question comes in the examination. Next question. The Supreme Court of India tenders advice to the President of India on the matters of law or fact. Yes, the Supreme Court can do this under Article 143 of the Constitution, which is also called as the advisory jurisdiction. It is advisory jurisdiction. But however, please understand, when the Supreme Court exercises advisory jurisdiction, only if the advice is sought by the President. The President has to seek the advice to the Supreme Court, and then only the advisory jurisdiction may be exercised by the Supreme Court, and that too it is not binding upon the Supreme Court to give advice on each and every matter which is referred by the President to the Supreme Court of India. If the Supreme Court feels that no need to give the advice, they can still, they may not give the advice. But on any important question of law or on a question of fact as well, or the interpretation of the Constitution, which may have a lot of impact on the functioning of this particular country, whenever the advice is sought, the Supreme Court will give the opinion. But there are instances where the Supreme Court has refused giving the opinion as well on a matter of fact. So, for example, in 1990s, the Ayodhya dispute issue was referred by the President to the Supreme Court to seek an opinion on this particular factual matter, where the Supreme Court has denied doing that. Okay, and subsequently the cases were filed, that's a different thing, but definitely not under Article 143 of the Constitution. So, with this information, come to the question. On its own initiative, the Supreme Court is never going to do that on its own initiative, and that is not possible under Article 143. If he seeks us advice, this is true. If he seeks the advice, then the Supreme Court may give the opinion. Only if the matter is related to the fundamental rights of the citizen, not necessarily. It can be related to a matter of fact as well. Any question of substantial, any question which has a substantial impact upon the public, any matter of law, substantial impact on the public, or it can be any other matter of interpretation of the Constitution. So, which of the statements given above are correct? So, that is option B only. Option B is the right answer. Come to the next question. With reference to Lok Adalats, which of the following statements are very correct? So, very good. In fact, Lok Adalats is not strictly under the judiciary. You can keep that under the miscellaneous topics also, but Lok Adalat is a form of an ADR, alternative dispute resolution, ADR. For ADR, please look into the questions that you have covered under the 100 most important topics. We have covered every aspects of the ADR. So, ADR means alternate dispute resolution, which the government and the judiciary is giving a lot of impetus today, because they wanted to reduce the burden upon the judiciary and also to provide a platform to the citizens which is non-adversarial in character. Non-adversarial means when you go to the court, in a court there is a strict prosecution, so there is a win-lose situation, whereas in out of court settlement like the alternate dispute resolution ADR, there may be a possibility of win-win situation. There can be a compromise, there can be a easy solution. So, all these things are available. So, now the government is promoting this ADR. So, one form of ADR is the system of Lok Adalat. So, all these things has been established under the Legal Services Authority Act 1987. The Legal Services Authority Act today has given a statutory backing to the orders that is passed by the Lok Adalat. So, what kind of disputes can be taken by the Lok Adalat? So, the Lok Adalat can take the disputes which are pending in the courts and those disputes which are in a pre-litigation stage. The matter is not yet filed in the courts, but provided all those offences are compoundable offences. The Criminal Procedure Code defines as to what is a compoundable offence. So, as per the Criminal Procedure Code CRPC, what is a compoundable offence? An offence where a compromise can be sought. These are issues that where a compromise can be sought between two parties. That is, one party is the petitioner and the other party is, that is, the complainant and the person who is the accused. So, if there is any element of compromise that can be achieved on certain offences, all those offences can be a compoundable offence. So, come to the first statement. Lok Adalat have jurisdiction to settle the matters at pre-litigative stage and not those matters pending before the court. Even those matters pending before the court, it can go to the Lok Adalat, provided that it is a compoundable offence. Okay, so this particular statement is wrong. Lok Adalat can deal with matters which are civil and not criminal. They can deal with the criminal matters as well, but it should be a compoundable offence. Again, this is a wrong statement. Every Lok Adalat should consist of both serving and retired judicial officers only, and not any of the other persons. So, whenever the statement only comes, remember, mostly it is a wrong statement. So, in this case also it is wrong. What the law says? The law says it can consist of a retired judicial officer, and along with that it can have a social activist also, not necessarily only the judicial officers. So, this particular statement is also wrong. In fact, what these judicial officers or the other people who are sitting there as a judge will do, they only act as a statutory conciliator. So, that means they will suggest the parties to arrive at so and so decision, and if it is acceptable by the party, then a binding order will be passed by the court. And as per the Lok Adalat, the order that is passed by, as per the National Legal Services Authority Act, the order that is passed by the Lok Adalat is equal to that of an order of the court, and there is no appeal that can lie against this particular order. Okay. So, what is the right answer in this particular case? The option is, that is, the answer is option D. None of the above statement is correct. Very, very important topic. So, many times it has been asked. So, we will discuss few more questions with regard to Lok Adalat when we take up the miscellaneous topics. Come to the last question for today. Consider the following statements. The Advocate General of a state is appointed by the President. So this very statement is wrong, because the Advocate General is the highest law officer for a state. So he is a similar position that of the Attorney General at the Union. While the Attorney General of India is appointed by the President, the Advocate General is appointed by the Governor, and he is not appointed by the President. So remaining things you can just correlate. Everything is the same as we have seen in case of the Attorney General. Upon the recommendation of the Governor concerned, so there is no such provision in the Constitution. As provided in the Civil Procedure Code, the High Courts have original, appellate, and the advisory jurisdiction at the state level. So as provided in the Civil Procedure Code, the High Courts may have original, yes, they may have original jurisdiction with regard to certain matters, especially with regard to the civil matters. They can have appellate jurisdiction with regard to both civil as well as the criminal matters, but they do not have any advisory jurisdiction. The advisory jurisdiction is only to the Supreme Court of India and not to the High Courts. So this particular statement is wrong. So the previous statement is also wrong. And in addition to the Advocate General, you can understand that he is the top law officer of that particular state. He defends a particular state government in the court of law. He is appointed by the Governor, holds office during the pleasure of the Governor. He has a right to audience in any court within the territory of the concerned state. And he performs a number of functions which the Governor asks him to do time to time, which is legal in matter, which is in his legal capacity. And then he may also take part in the proceedings of the state legislature, and he can defend the state government. He exercises certain privileges when he is part of the proceedings in the state legislature, but he or she shall not exercise the right to vote in the houses. So all these things try to remember. And anybody who is appointed as Attorney General will have the same, should have the same qualification to be appointed as a judge of a High Court. Okay, remember all those things. You may expect a question from this area also. So with this, which of the following statement is all right? It has neither one nor two. So today we have covered around 25 questions. Again, we have completed the legislature. We have started up the judiciary. So next class, I think few more questions are there with regard to the judiciary. We will try to complete judiciary in the next class, and we will also try to cover the local bodies and the constitutional bodies. And then in the last class, we will try to take up some of the miscellaneous topics, and we will have a summary of the important themes from all these topics, the subtopics from all these topics, so that can also help you to have a quick revision on these areas. Okay. So I hope these videos will be very useful to the students, and we'll continue with the next set of lectures in the next set of questions in the next lecture. Thank you very much. All the best. God bless.